It's apprehended that net application form might come out any time in the month of April, and hence the exam is likely to occur in the month of June or July. So, in a midst of your preparation, I'll provide the list of some important case laws under Negotiable Instrument Act. Hello and welcome to Research Academy. Since Negotiable Instrument Act, or in short I must say it as NI Act, does come under the commercial law as per the net syllabus. Though it's a minor act, but we have already witnessed in previous attempts about the significance of minor acts. So let's start it. First case is Yogendra Pratap Singh versus Savitri Pandey, decided in year 2014. And in this case, the proviso C to section 138 is being described over here, which clearly stipulates that the cognizance of offence which is being given under section 138 cannot be taken unless the drawer of the checks fails to make the payment to the payee within 15 days of the receipt of the said notice. Second one is Dashrath Roop Singh Rathore versus State of Maharashtra. This is also a case of 2014. And if we talk about section 138, it is one of the most celebrated case that comes under section 138. So under this case, the Supreme Court has finally ruled on and clarified a very complicated issue by holding that place where drawee bank is situated will only be the place for judicial inquiry and trial for section 138 complaints. So with the Dashrath ruling, the judicial inquiry has been restricted to the place of the commission of office, so to restrain abuse of section 138. The third one is in re expeditious trial of cases under section 138 of NI Act, and this is one of the recent case which is decided in year 2021. So the Supreme Court had observed that there is a steady increase in the institution of complaints under section 138 of NI every year, which has resulted in high pending cases before courts. So hence, Constitution Bench of the Court taken this case suo motu, and on the basis of the recommendations made by a court-appointed committee for the expeditious trial in the check dishonor cases, had issued some directions, like magistrate must record reasons for converting section 138 complaints from summary trial to summoned trial, or the inquiry shall be conducted under section 202 of the code on the receipts of section 138 complaints when such accused resides beyond territorial jurisdiction. So there are other directions also likewise. You may also pause this video and go through the directions accordingly. Our next case is Abbas Haji versus T.N. Channakeshav, decided in year 2019, wherein it was held that in case of death of convict in offence under section 138, the legal heirs are neither liable to pay fine nor to undergo imprisonment. However, they have the right to challenge conviction of their predecessor only for the purpose that he wasn't guilty of any offence. Moreover, in this case, it was also held that the proceedings which are taking place under section 138 of NI, they are quasi-criminal in nature. Our next case is Sunil Todi versus State of Gujarat, decided in year 2021. So here in this case, the phrase debt or other liability is widely interpreted just to widen the scope of debt. If we refer the explanation to section 138, that provides that debt or other liability means a legally enforceable debt or other liability. By mentioning the term other liability, of course, it is giving the widest scope to the nature of debt. And the very object of the NI also is to enhance the acceptability of checks and inculcate faith in the efficiency of negotiable instruments for transaction of business. So hence, the Supreme Court has held that this section 138, also attracts the cases where debt is incurred after the checks is drawn but before their presentation. Now the last case in our list is P. Mohan Raj versus Shah brother, and it is one of the recent case. So there was this one specific question which was raised in this judgment, that whether the scope of section 14 of Insolvency and Bankruptcy Code, which is IBC 2016, so would it cover section 138 proceedings of NI Act? So it was held that the word proceeding which is used under section 14, it does include the proceedings under section 138 of NI Act conducted before a magistrate. Why? Because it was interpreted that the proceedings under section 138, they are of quasi-criminal in nature. The court reasoned that the proceeding is civil or criminal in nature is not to be judged with the reference to the penalty that may be prescribed, but with the reference to the cause for which the penalty has been inflicted. Hence, these were some cases presented before you in a crisp manner so that you can quickly revise them in no time. Thank you for watching this video. Please like and share this video with your friends and do subscribe Juris Academy to get the further updates.